much, Pinaki, for introduction. And so today, my topic is primarily to look at the paradigm shift which has happened in Indian litigation landscape. As Shantanu very well referred to about the policy changes which have been brought by to make Indian system, IP system, in compliance with the TRIPS agreement which we signed in 1995. So probably if we look at the Indian litigation space also, it moves into the similar position. The type of, the period of the policy change also corresponds to the period of change which brought in the Indian litigation system. So primarily we look at from two decades, when 1995 when India signed TRIPS, 2005 when we got the time up to 2005 to implement the TRIPS agreements provisions in law and in practice. And from 2005 to 2015, just last decade which passed by, and primarily from the perspective of the implementation of TRIPS provision at the litigation stage. So two clear-cut phases we identify in this in the Indian litigation side, where the courts have taken two views, particularly from 95 to 2005. That is the area to prepare the grounds of for enforcement, bring in the internationally well-recognized principles of IP enforcement, provide teeth to the enforcement system here in India, and so that's point. So first let's get into the numbers of the litigation, how it evolved from 1995 to 2015. So during this 20 years period, we have about 2,345 reported IP cases. When I say reported IP cases, means those which are reported in different law journals, which roughly represent about 20% of the litigation filed, actual litigation which are filed. Calculating from there, it's around 10,000 IP litigations which are filed in India during this 20 years. The 80% which are non-reported cases are primarily do not get reported because of the reason that they settle at the very early stage. And out of the 80% is expected is that about 90 to 95 cases are there, they're not reported just because of they settle. And settlement takes place at either at the grant of the ex parte injunction itself. So once the defendant comes, and the settlement takes place. So if that process happens, so primarily litigation lasts not more than 2 months of a time from the date of institution. If ex parte injunction is not granted, an interim injunction is given after after it being contested by the defendant, then probably it takes about 6 to 9 months to get it settled. So 80% of the IP litigation closes within the time frame of 2 months to 6 months from the date of institution. These 2,345 cases which go on trial, and they are the one which takes time of about 4 to 5 years. What we talk about, the delay in litigation are being faced in that. So only 20% of those litigations get into that. Delhi High Court almost receives about 600 IP litigation a year, which is about the 20% of the total suits filed on the original side of the Delhi High Court. So say about 3,400 original suits were filed last year. Out of that, 600 were IP litigation. So quite a significant and big number insofar as Delhi High Court is concerned. Similar situation would be there in the Bombay as well. Then large number of cases being started, we started seeing decisions coming out after the full trial. So in 2005, the numbers was about 209 IP litigations were finally decided after the full trial. That number rose to 533 in 2015. And out of this numbers, 40% of the IP litigations are being filed by the foreign nationals or entities, as a right owner, and in 65% cases filed where the cases are decided in favor of the IP owners. So quite a good IP friendly and non-discriminatory court system as against the perception of it. This is some fresh filing numbers of 2014. So about 450 was filed in Delhi High Court, which rose to 600. Similarly, in Bombay High Court, it was about 90, which has rose to about 245. This litigation, nature of the litigation is what we look at is from 95 to 2005, primarily the IP litigations were in the nature of trademark, copyright, design violation. The nature of the defendants were primarily willful infringement, blatant violation, particularly trademarks which are well-known marks, which are very well-known internationally but not being used in India. So many businesses adopted that. Despite several warnings given by cease and desist letters issued, they were not willing to give up. So the first phase of 1995 to 2005 was the litigation against the blatant and willful infringement by the defendants. So therefore, court realized that it need to be to set the legal system in a way where there's defendants, particularly the willful defendants, like those who receive repeated notice and still willing to not to give up the marks or the copyrighted work. So the first phase was the court where they started adopting the internationally well-recognized principles, primarily not from the perspective of a substantive law, but also from the perspective of procedural law, so that the sufficient effective tools are ingrained in the system, which are there we saw during this period that anti-pillar order first been used, that is appointment of a local commissioner to seize the goods of the defendant at defendant's location, so that the court extending their hand not only remaining within the courtroom, but extending their hand and getting up to the defendant's business location, appointing its officer to go and search the premises, seize the goods. Similarly, there's an order came first time during that period of a John Doe nature, where the number of defendants and the names of defendants were not known, but that particularly in the terms of media cases where the order was a roving order in terms of that any time a defendant is identified, it can be used against it. Then there came the Mareva injunction again in 2004 in Phillips' case. Norwich Pharmacal order again was first time, and these are the precedent-setting cases where systems, Indian litigation system, Indian enforcement system has received the effective tools to stop that blatant and willful violation, because primarily the nature of the defendants coming to IP litigations was that. Similarly, the first case of right to privacy came in that in Bandit Queen case. Then concept of dilution of mark was being recognized. Concept of trans-border reputation was recognized during that time, because of many brands which are up till 1991, many businesses were not coming to India because of the policy restriction or import restriction. But the presence of those marks or brands were well known to Indian businesses, and most of them were being adopting it, and is still even if those marks, those brand owners, when they started coming in India, the defendants were not willing to give up. So these principles were adopted to bring the litigation system in compliance with the TRIPS requirement. Then came the second phase of when the law. Statutory law was primarily amended to bring the legal statutory provision in compliance with the TRIPS agreement. But then came a lot of gaps during the implementation of those legislation. Came a lot of gaps during the practice, and then court took a proactive approach to fill up those gaps, particularly in terms of patent law. When it was implemented in 2005, there was many gaps which were not being addressed, which could not be addressed by the patent office or from the appellate board at that point of time. So the court, in its extraordinary jurisdiction of writ jurisdiction, took up those cases and filled up those gaps, particularly making provisions for the opponent in a pre-grant opposition, then allowing appeal to the order of refusal of patent application in a pre-grant. Then there was a controversy related to which is the date, what amounts to the date of grant of a patent, particularly from perspective of pre-grant opposition. So the court Snehata Gupta case came, and then doubts were cleared on that. Then there were practice doubts which were coming from the patent office, particularly regarding to arbitrary abandonment of patent application in Section 21. So court looked at that provision also, cleaned it up, and then brought it to the stage where legal system has got a sort of a consistent view. Then Supreme Court came in closed the controversy on the 3D, which was talked almost globally everywhere. Then efficacy, what amounts to efficacy, being decided as a therapeutic efficacy. There was a controversy relating to multiple proceedings of revocation. That's also been settled by the Supreme Court. So that's a phase. So one phase was where the blatant